Well, hello there. Welcome to Uncivil Law. If you're thinking to yourself, this stream just started 5 minutes early, you're correct. I'm starting the stream 5 minutes early because I can. Welcome to Awesome Law Done Quick. The game we are playing is Last of SCOTUS edition. Excellent. Yes. And so this is maybe, possibly, the last day of the Supreme Court term. It normally is. Like every other normal year, it's the last. But I don't know. The rumors are flying. Let me just put to the state of things. My understanding is there are 9 cases to be released. That's a lot. I don't know what the most released in any given day is in the history of the Supreme Court, but I'm pretty sure it's not 9. We might have gone up to like 6. 9 is a lot. So the rumors are flying in Supreme Court land because, of course, they are, because the Supreme Court doesn't tell us what they're going to do in advance. So everything is reading tea leaves, which is part of the fun of playing Last of SCOTUS, the game. Yeah, and so we're here. So I'll give you. We may or may not find out where Tulsa is today. Will we find out where Tulsa is today? I don't know. We might, or we might not. We're going to find out together. Exciting. And we'll also find out what other stuff is going on. Oh, and also there's a kind of tradition that isn't like really a tradition, but there's a little bit of a tradition. So it has been true occasionally, but not every time, but it has been true occasionally, that if a Supreme Court justice is going to retire, they announce it on the last day of the session. That hasn't always happened. Sometimes they've announced it other times. But it's enough of a tradition that people are poking their head up and be like, ooh, will we get an opening on the Supreme Court? Will someone announce that they're going to retire? That could be fun. Yeah. So that could be super, super fun. And Trump apparently, CNN is apparently reporting that Trump has said he wants to confirm another female Supreme Court justice by the end of the year. And we all know who that is, right? We all know who that is. It's Amy Coney Barrett. We know spoiler, it's Amy Coney Barrett. Yeah. Yeah. So who will be retiring? I don't know. The rumors have been that Justice Thomas has been looking to retire. He's the oldest member of the court. And he's been there. I think he's the oldest. I'm pretty sure he's the oldest. He's definitely been there the longest. I know that from seating order. So I know he's been there the longest. And he's looking to retire. But he said like a year or two, like last year, the rumor was he was going to retire. And then he kind of said, no, I'm not looking to retire. But the rumor is maybe he's going to retire. So he's a possibility. Of course, Ginsburg could retire. That would make life fun. I mean, she's had many health problems over the years. She's beaten cancer like 4 different times. She's had her lung punctured and all kinds of stuff. So Ginsburg could announce a retirement. That would make this would make this year of 2020 just the best year. Wouldn't it, if Ginsburg announces a retirement and then everyone says, oh, wait, I thought we weren't supposed to nominate and appoint a Supreme Court justice during the last year of a presidential term, because that was the whole justification by the Senate for upholding or preventing the nomination of Garland was, oh, we're not supposed to do this in the last year of a presidential term, which isn't a rule, but we can make one up. So sure, it's a rule now. So if someone retires, will Trump make a nomination? Will the Senate go completely apeshit because President Trump and Mitch McConnell will be massive hypocrites? Will they go even more apeshit because that nominee is Amy Coney Barrett, who is to the right of Thomas, and I didn't think that was possible. These are the questions we get to ask each other on Awesome Law Done Quick. So we have that whole side. We have that whole that is the B story. That's not even the A story. That's the B story of this game. Will a major character leave the story? Will a new major character enter the story? Possibly find out on this edition of Supreme Court React. Yeah. And yeah. So we're going to find out if someone wants to retire. Will it be Justice Thomas? Will it be Justice Ginsburg? Maybe Justice Breyer, who's probably my least favorite justice, is Justice Breyer. Yeah. Will it be Justice Breyer? Will it be the Chief Justice for some reason? That'd be good. That'd be hilarious. Let's let Roberts retire for no particular reason. That'd be good. Why not? Let's throw that in there. Then we can appoint Amy Coney Barrett as the new Chief Justice. That'll get everyone super excited. Let's throw that in there as a possibility. Sure, why not? So yeah, we may get an announcement of a retirement. We might get a huge fight. Like the fight that we would have over, especially if Ginsburg retires, the fight we would have would make the Kavanaugh and Gorsuch hearings look like a picnic. It looked like a summer party. So yeah, the Senate will go completely crazy. The public will go completely crazy. Yeah, all that stuff. So that will be super fun. And of course, the Senate will ignore the precedent it just set, because of course it will. And they will confirm the nominee, whoever it is. It's Amy Coney Barrett. And she's to the right of Thomas, and the left will go completely batshit insane. Amy Coney Barrett doesn't care about precedent at all. Here's all you really need to know about Amy Coney Barrett. First of all, she doesn't care about precedent at all. And second of all, she really doesn't like abortion. So, there you go. That's what you need to know about Amy Coney Barrett. She doesn't like precedent, and she doesn't like abortion. You now know everything there is to know about Amy Coney Barrett that is relevant to this discussion. Yeah, good times. So, we are going to do that, maybe. And yeah, so that's the B story. And then the A story are things like, where is Tulsa? Will Trump have to give up his tax records? Is Booking.com a valid trademark? That's the one we're all really excited about, right? That's the one we all really care about. Is Booking.com a valid trademark? That's what you guys come for. So we will get somewhere between 3 and some other number of decisions today, probably. And if we extend the term past today, then I don't know the last time that happened. Seriously, I don't know. Like, the Supreme Court always ends its term the last day of June. Today would be the last day of June for those of you playing at home. So if the Supreme Court holds over things, well, that's a whole nother level of weird. And so then we have to figure out when they're going to issue those opinions. I don't know. They have a cleanup conference tomorrow. I think they're announcing orders on Thursday, which are like cert denials or cert grants. So they could throw it into the orders on Thursday. That'd be interesting. And then Friday, of course, is a holiday in preparation for the 4th. So they're not meeting on Friday. And then I guess we're into next week. So good times. Yeah. Yeah. Amy Coney Barrett, I think she's I mean, yeah, she's a smart woman. She's certainly capable of having the seat. She's Catholic. She's got a lot of kids. I forget how many. A lot. She's Catholic. So, some number of kids, that is a notable number. And yeah, that's what you need to know about Amy Coney Barrett. Yes, and the cases will start coming down in 5 minutes-ish. And what we will do is what we did last time. So yeah, this is awesome law done quick. So there's about 10 minutes-ish in between the decisions when they're released. So what I'm going to do for you is every time a decision comes down, I'm going to load it. I'm going to speed read it and speed explain it. So my goal My goal for you, for however many number of cases we have, somewhere between 3 and 9 cases, which are being released at roughly 10-minute increments, my goal is to read them, understand them, and explain them in under 10 minutes each. Yeah, this is a speed run. This is a speed run. This is a speed run of an unknown number of cases of many complexity, and if one of those cases is where's Tulsa, the odds of me being able to understand and explain that in 10 minutes are basically zero. So that'll be the real challenge run. Yeah, if they release the Where is Tulsa case, the odds of me being able to understand, comprehend, and explain it in under 10 minutes, well, we're going to see just how much of a pro gamer I am today, I guess. We have the 5-minute buzzer, kids. The buzzer has gone off. We have your 5-minute warning. Oh, and incidentally, just in case you're curious, because I mentioned this before, the cases are announced in order of seniority of the person who wrote them, or reverse seniority. So Kavanaugh, if there's a decision from Kavanaugh, it would be announced first. And then if there's an opinion from Gorsuch, it would be announced next, and so forth and so on. So we can get at least a rough idea of how many cases there might be based on who's announcing it. Now, the only time that really isn't followed is if there's 2 cases being announced and one depends on the other, and the one that's dependent has to be announced first. So, like, if there's 2 cases that are being decided at the same time, and it occasionally happens, 2 cases that are being decided at the same time, and one case that's being decided depends on the result of the other case that's being decided, then they will announce the one that's the predicate first. So even if it's a more senior justice, that's the only time they skip order. Even if it's a more senior justice, you obviously announce the predicate case before you announce the follow-on case, because otherwise it wouldn't make any sense. So that's the only time they skip other order. Otherwise, it's reverse order of seniority. And seniority order is determined by how long you've been on the court, and of course the Chief Justice is definitionally most senior. So that's how you know seniority. How long have you been on the court? Unless you're Chief Justice, you're automatically most senior. Good times. I dropped my water bottle. Please give me a minute. All right, I've got 2 minutes. That's just enough time to use the restroom, so I'm going to do that. Be right back. All right, guys, it is 10 o'clock on the dot. Are you ready? Dun 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 dun. Let's do this thing, baby. It's 10 o'clock. It's 10 o'clock on the East Coast, baby. Let's do this thing. Let's figure out what the law is. Here we go, kids. Oh, yeah. That's helpful. Smash the dislike button. I prefer you not smash the dislike button. I am being constrained by the U.S. Supreme Court. I can only do things as fast as the U.S. Supreme Court can do them. So, we'll find out. All right, guys, we have your trademark case. Booking.com. For all you trademark junkies, is Booking.com a valid trademark? I'm going to predict the answer to this question is no. Let's find out if I'm right. Here's a link, guys. All right, you ready? USPTO. USPTO versus Booking.com. A generic name, the name for a class or product of services, is ineligible for federal trademark registration. Yes, you can't get a trademark on something that's generic. Respondent Booking.com, an enterprise that maintains a travel reservation website by that same name, sought federal registration of the mark, including the term Booking.com. So you can't get a trademark for the name Booking. The question is, can you get a trademark for the name Booking.com? That was the question. I'm still saying the answer is no. Let's read on. Concluding that Booking.com is a generic name for an online reservation service, which, the USPTO refused registration. Fine. Booking.com sought judicial review, and the district court determined that Booking.com, unlike the term booking, is not generic. So the district court said this is fine. The Court of Appeals affirmed, finding no error in the assessment of how consumers perceive the term Booking.com. The appellate court also rejected the PTO's contention that, as a rule, combining the term like booking with com yields a generic result. Held. A stylist term, generic.com, is a generic name for a class of goods or services only if that term has its meaning to the consumer. So it looks like I'm about to be wrong. So I predicted this the wrong way around. Okay. Whether a compound term is generic turns on whether the term taken as a whole significance to a class of goods or services. The court below determined the PTO no longer disputes that consumers do not, in fact, perceive the term Booking.com that way. Because Booking.com is not a generic name, it is not generic. So I was wrong. Booking.com is fine. Opposing the determination, the USPTO urges a nearly per se rule. When a generic term is combined with a generic internet domain like .com, the resulting combination is generic. The rule that the PTO proffers is not borne out of PTO's own past practices and lacks support in law or policy. The proposed rule is not a follow-on case from Goodyear. Goodyear, the PTO maintains, establishes that adding a generic corporate designator like company to a generic term does not trademark eligibility. So Goodyear is not eligible, Goodyear company is not eligible, and com might be the same as company. That was the argument. According to the PTO, adding .com, like adding company, can convey no source identifying meaning. Reasonable. That premise is faulty, so apparently not reasonable. For only one entity can gain a particular internet domain at a time, so generic.com could convey consumers in association with a particular website. Moreover, an unyielding legal rule that entirely disregards consumer perception is incompatible with the bedrock principle of the Lanham Act. The generic or non-generic terms depends on the meaning to consumers. Do consumers in fact perceive the term as a name of class of goods or a term capable of distinguishing? The PTO's policy concerns do not support a categorical rule against registration of generic.com. Or Booking.com in our case, whatever. The PTO asserts that trademark protection for Booking.com will give the mark undue control over similar language that others should remain free to use. That concern attends any descriptive mark. Guarding against the anti-competitive effect the PTO identifies, several doctrines ensure the registration would not yield its owner a monopoly on the term booking. So Booking.com does not give you control over the term booking. It gives you control of the term Booking.com. Now, how that would relate to booking.org, booking.whatever, is yet to be decided, but yeah. The PTO also doubts that owners of generic.com brands need trademark protection in addition to whatever competitive advantages they would have. Such advantages, however, do not inevitably disqualify a mark. Finally, the PTO urges that Booking could see remedies outside trademark, but there's no basis for denying. Ginsburg delivers the opinion, so this is an 8-1 opinion. So I was very wrong, so fair enough. There you go. 8-1. Uncle Blackleaf got that one wrong. Okay. Predicted the wrong outcome. Oh well. Now we know the law. The law is, yes, you can get booking.com. Now, if a different company, so this is the challenge. If a different company wants to get booking.org or booking.tv or booking.io or booking.fill in the blank, how does that work in trademark law? Good question. Many lawyers will be spending much time trying to figure out the answer to that question going forward. So, all you who want to do some trademark law, there's some brand new things for you to figure out. Good times. Oh, who wrote this, by the way? Ginsburg wrote it. Well, Ginsburg is the third most senior justice. So that suggests we're not getting our 9 opinions today. Ginsburg is the third most senior justice, so we're apparently not getting our 9 opinions because it's pretty unlikely that the 3 most senior justices each wrote 3 opinions, give or take. So it looks like there will be another day for Supreme Court React. Somehow, even though it's the last day of June. Okay. Yeah. So that was easy enough. Ginsburg is, Ginsburg is the third most senior. So therefore, you would predict that there would not be many cases because it's unlikely that there are 9 cases being issued by 3 judges. So you would predict that there are not that many cases today, and we're going into overtime. So, good times. Yeah, June the 31st is apparently now a thing, I guess. Oh, man. We'll get Last of SCOTUS Part 2, which may or may not be as good as Last of SCOTUS. Yeah. I don't know, man. Any chance there's only one case? Yes, anything is possible. The Supreme Court can do lots of stuff. So yes, this could be the only case announced today. Or maybe Ginsburg wrote 9 opinions. Any of these outcomes are possible. Or maybe for some reason they're going out of order for a reason I can't begin to fathom. So, we will do it. We're just making shit up now because normally we have a last day of June and today would be that day. So maybe Ginsburg wrote 9 opinions, or maybe we're going out of order for some reason. I don't know. But this is what we're doing now. Ginsburg just wrote an opinion. So there may be more opinions. We'll find out together. I don't know what to tell you other than that. Yeah. It doesn't exist until it's announced. All right, so that was fun. Yeah, Breyer was in dissent. Breyer was in dissent on that one, so I guess it's me and Justice Breyer somehow alone. We have a new member, Herbert Hermison. Thank you very much, Herbert. Incidentally, I believe we are 8 members away now from having 100 members because I looked it up earlier. So if you'd like to become a member and help me cross the 100-member threshold, you can be like Herbert. So if 8 of you want to become members, now will be a great time. Also, I want to congratulate A. Hedinger for being a member for 2 months because he's got a cool yellow thing, which means and Jan too, for being members for 2 months. So they get a cool different color because they've been a member for 2 months. Very exciting. And we wait and we wait and we wait and we wait, and we wait and we wait 8. Yeah. So we are waiting because if they go faster, they break the website. That's probably true. Yeah, we are trying to keep the Supreme Court website from breaking. When they wrote that gay marriage decision, no one could download it for like an hour. Yeah, that was good. How do you become a member? There should be a join button somewhere on your screen, somewhere near where the subscribe button is or would be. So somewhere near the subscribe button, there should be a join button. If you press the join button for 99 cents a month, you too can become a member, and you can be an uncivilian, and you can be a cool guy. So theoretically, somewhere where there's the subscribe button, there should be a join button. Press that. You can become a member. Good times. We have a decision in Espinoza. I don't remember what that case is about off the top of my head. We're going to find out real fast. July 1st might be June 1st, right? All right, so we have a decision by Roberts, which again is pretty suggestive that we are not doing all the opinions today. So let's speed read this. Espinoza versus Montana Department of Revenue. Okay, so this deals with religious schools and whether or not certain religious schools get certain monies. I believe I covered this, and I forget how I predicted the outcome on this. So someone will have to go back and see what my prediction was, because I can't remember. But this deals with essentially giving money to religious schools. I think I predicted that the nature of the award, I forget which way it was, because I think there was some like fact specific detail that would turn the legal analysis, because I think in general that they're probably legal, but I forget if there was something fact specific that made me predict this the other way. So I forget which way I went. Anyways, the Montana legislature established a program that grants tax credits to those who donate to organizations that award scholarships for private school tuition. To reconcile the program with a provision in the Montana Constitution that bars government aid to any school controlled or whole in part by any church, sector, or denomination, the Montana Department of Revenue promulgated a rule which prohibits families from using the scholarships at religious schools, which makes sense because it's a violation of our Constitution, but maybe not a violation of the U.S. Constitution. 3 mothers who were blocked from the rule by using school funds for the school tuition at Stillwater Christian School. Yeah, so I think I predicted the Montana decision was going to be overruled, because I think I predicted that this would be okay using neutral principles. So I think I predicted Montana was going to lose. 3 mothers who were blocked from using this scholarship fund at the Stillwater Christian School sued the Department of State Court, alleging the department discrimination on the basis of religious views and the religious nature of the school they've chosen. This trial court enjoined the rule, reversing the Montana Supreme Court held the program unmodified, aided religious schools in violation of the Constitution. The court further held that they violated invalidating the entire program. So the Montana Supreme Court said, no, this is no good, and we're going to kill the entire program. Hell, the application of a no-aid provision discriminated against religious schools and families whose children attended or hoped to attend it in violation of free exercise. So, yes, you can give this money. The Free Exercise Clause protects religious observers of unequal treatment and against laws that impose special disabilities on the basis of religious status. In a prior case, this court held that disqualifying an otherwise eligible recipient from public benefit solely because of religious character imposes a penalty on the free exercise of religion that triggers the most exacting scrutiny. Here, the application of the Montana no-aid provision excludes religious schools from public benefits solely because of the religious status. As such, strict scrutiny applies. Contrary to the department's contention, this case is not governed by a prior case. The plaintiff in that case was denied scholarship because of what he proposed to do, to use the funds to prepare for ministry, an essentially religious endeavor. By contrast, Montana's no-aid provision does not zero in on essentially a religious course of instruction, but rather bars aid to a religious school simply because of what it is, a religious school. The prior case also invoked a historic and substantial state interest in not funding the training of clergy, but no comparable tradition supports Montana's decision to disqualify religious schools from this governmental aid. The proposed alternative approach involving a flexible case-by-case analysis is inconsistent with the law. The protections of the Free Exercise Clause do not depend on varying case-by-case analysis regarding whether the discrimination against religious adherents would be ill-served. To satisfy strict scrutiny, government action must advance interests of the highest order and must be narrowly tailored. Montana's interest in creating greater separation of church and state than the federal constitution requires cannot qualify as compelling in the face of the infringement of free exercise. The department's argument that because an infringement of the free exercise rights cannot be justified by the state's alternative view, that infringement advances religious liberty. The department's argument is expressly unconvincing because infringement here burns not only the religious schools but also the aid. The department suggests that no aid provision safeguards the public education. Because the Free Exercise clause barred the application of no aid, the Montana Supreme Court had no authority to invalidate the program on the basis of that provision. Interesting. The department argues that invalidation of the entire program prevented free exercise violation, which is a reasonable argument, but the department overlooks Montana Supreme Court's threshold error of federal law. Had the Montana Supreme Court recognized the application of the no aid provision was barred by the free exercise clause, the court would have no basis for invalidating the program. The court was obligated to disregard the no aid provision to decide the case consistent with federal constitution. So this looks like it's an 8-1 with Sotomayor in dissent. Okay, that seems perfectly reasonable. So this is using the Lemon versus Kurzweil test. This is a general program of neutral applicability. We are giving money to any school. All the schools that are otherwise qualified as schools. The fact they're religious or not is irrelevant because it's a general rule of neutral applicability. And it's up to the person to decide where the money goes because the money is based on the parent. So the parent can make the decision as they wish. For any school that qualifies as a school, religious or otherwise is fine. So that means, incidentally, that if there's an Islamic school out there, that they would have to be, so you have to fund all religious schools the same. So that means you have to fund Jewish schools, and you have to fund Islamic schools, and you have to fund Buddhist schools, and any other school that qualifies as a school. So as long as it meets the educational curriculum requirements of whatever relevant state law in order to be functioning as a school, as long as you're doing that, religious is irrelevant. So there you go. Welcome, Phoenix, for being a supporter. Congratulations. Well, it looks like we're done. 2 and out. Well, that was anticlimactic. We didn't get our 9. We got 2. So guys, I'm sorry. We didn't find out where Tulsa is. I know how disappointed you are. And we also didn't find out about Trump's tax records. But we did find out about Booking.com, and that was the most important lesson of all. So, that's that. You don't always agree with me, but you want to support me. I appreciate that. I appreciate that you support my right to speak, even if you don't always agree with me. Hopefully, I present them in a level-headed, clear, logical, consistent way. So hopefully my logic tracks, which is all that I can really hope for. So, good times. When the Supreme Court come back, I have no idea. So I'm going to just stay here for a while and see if SCOTUS blog will say if there's any announcements from the court. So we're going to be here for a little minute while we wait to see if the Supreme Court wants to make announcements as to what they're going to do. Are they going to put off to, this will be fun. Will they put off to releasing decisions? Wow, that would be great. So I guess you have one of 2 options now, both of which are pretty interesting. So you could release these opinions, presumably sometime in July, which would be pretty weird. Or, also weird, you could hold them over and release them at the start of next session. The start of the next session of the Supreme Court is October the 1st. I apologize, it's the first Monday of October. Not October the 1st. It's the first Monday of October, whatever day that is. So I don't know what day of the month that is, but it's the first Monday of October. So you could wait and release them in October, which, lest I have to remind you how calendars work, October is the month immediately preceding November, which we have an election in. So you could do that. That'd be good. Excellent. Talk about your October surprises. Ugh. Yeah, so we could hold them off until the Supreme Court starts its next term in October. That would be good. I don't know if the Supreme, I assume it must have happened, but I can't think of any time when the Supreme Court has not made all of its decisions by the end of June. Obviously they did it in the Oklahoma case, but even then the decision was to order re-argument. So even in that case, they just ordered re-argument. I'm pretty sure they did that by the end of June. So even the Oklahoma case, which they deferred, they said, "Oh, we're just going to wait and have argument again." I think they did that by the last day of June. I'd have to go check, but I can't think of any time when they've just like held over decisions. So this is a whole new world of what the hell is going on. Where are we at? I don't know where we're at. We're in a mystery. We're in a new world. We're in a whole new world where things are not as you left them. Yeah, we with this SDNY guy gone. Do you think the SDNY case for Texas could be swept under the rug? Um, Possibly, but one of the other issue, there was the one from SDNY, and there was also the one from Congress. So Congress isn't going anywhere. We're still waiting, incidentally, for any sort of information from the Supreme Court. So we're just going to be here for a while. Apparently, apparently, Alito, in his opinion, put in a cartoon in the opinion. So there's graphics in the opinion. Okay, well, apparently we're doing Supreme Court opinions by 19th century political cartoons now. Mm-mm. This is Black Leaf is 50% today, something like that. Yeah, something like that. Yeah, I thought the addition of .com was going to be a little bit too generic, so I guess I was wrong. Oh well. We are continuing to wait for the Supreme Court to do whatever it's going to do. So ask me other legal questions, and if the Supreme Court says something, I will immediately start ignoring you and talking about the Supreme Court. But until that happens, I will take other legal questions. Q Squared's asks, are they not releasing other decisions? That looks like what's happening, yes. Like 8 or more, did they release 1 or 2? Yeah, they released 2, and there's a whole bunch that are not released, and we're still waiting to figure out what the heck is going on. They released 2, and apparently they're done somehow. If I have time, I could scroll over the art. I'd have to find it. Okay, yeah, hold on, I can find it. Oh, got it. You're about to be very disappointed, guys, but here you go. Ready? Okay, so this is a picture of what looks like some school children being held back by what I would describe as a prefect at a beach, in which there are what we're going to call alligators, I guess, in a river, um, at a cliff. There's some other people on the cliff. There is a Capitol building in the background with flags flying, or maybe it's a church because it looks like it has a cross on top. So there's a church in the background. Then there's looks like a fort with a flag hanging over it, and this cartoon is titled "The American River Kansas." Okay, well, oh, or maybe it's Dangers. I guess it's a D. The American River Dangers. Okay, well, now you were edified by your cartoon. So that's apparently relevant to the decision in some way. Yeah. No, we are not discussing the definition of escape in Georgia anymore. No. The American River Ganges. Yeah. One of our only real rules here is we do not allow people in chat to insult other people in chat because it is not productive. We require people to be nice to each other. We require a certain level of civility to each other as we have differing points of views. So the mods have every right, if you are being mean to other people in chat, to block and ban your butt. And I won't feel bad about it because it is a rule. You can have an opinion, you just can't insult other people in the chat. And other people in the chat, if you don't like what that person says, you can block them personally, just in general. So if they're discussing things you don't want to hear, you can block them. That's cool. I have no problem with that. You're not required to listen to anybody, including me. Yeah. And I guess we should probably have a rule of keep it vaguely on topic, because that can get a little bit dicey. So we probably can have a new rule. So effective immediately because I am God of this channel. Yes, effective immediately, new rule. The chat in channel has to be vaguely on topic. So, related to the case in some way. So random proselytation is not permitted anymore because I say so. Excellent. That was easy. Yeah, we're still waiting on the schedule. So we're still waiting on the Supreme Court to do whatever it's doing. Rocks falls, everyone dies. I get the reference. Excellent. Total player kill, TPK. Good work. Yeah, you can insult RBG, I guess. I mean, she's not in the chat, presumably. So, I guess. I'm not sure I'd necessarily recommend it, but yeah. Yeah. And we're still waiting for the Supreme Court to announce whatever it's going to announce, so we'll take other question. Off topic, Barnes on Viva Fry stream say he believes OJ was innocent. What are your thoughts on this? I mean, I think the information is out there, and people can make their own conclusions one way or another. So if you feel like the facts are relatively well known at this point, particularly in history. The man did write a book called If I Did It, with the word if in very small letters, which is not like super encouraging. So, the information's available for you to reach your own conclusion, I suppose. I will say I was a little bit sad personally when OJ was paroled from Nevada because he was being held in prison. He was convicted, for that matter, for kidnapping, false imprisonment, and robbery. And I was sad when his prison term came to an end and the juice was allowed to be loose. So, yeah. I did start early, Tony. I started 5 minutes early, but we're still here. The crocodiles are Catholic bishops. That makes a lot of sense. They didn't look quite like crocodiles. They did look like some sort of religious thing. So they were Catholic bishops. That makes a lot of sense. Yeah. So the Catholic alligators or crocodiles are trying to eat the children near a church. I'm not sure what the cartoon is trying to say, but yeah, whatever. Wasn't the change made after the book was taken by civil suit? You might be right. Historically, that might be true. You might be correct. Still, even if you're right, he still did write a book called If I Did It. I'm like, okay, great. Are we not sure, OJ, whether or not we did it? You see a documentary that makes a good case that his son killed Nicole and OJ was protecting him? Sure, that could be. I mean, the information's out there, so you can draw your own conclusions. You don't need me for that. What are the charges the gun wielding couple in St. Louis could face? Presumably brandishing would be the most obvious charge. Is particularly if the firearm was pointed at anybody, which it looked like in some of the shots it might have been. Some of the photographs looked like it might have been. So brandishing is the most obvious charge. Um, and then you could presumably get into other charges depending on like if depending particularly like on the words that they said. So if anything, because I didn't see like everything, if they were saying things that could be viewed as threatening with the firearms, then that could be like maybe assault. So it could be you could get into some like armed assault arguments, um, because assault is can be just words. So you could get into some armed assault. And those would be the charges that would be most obvious. Isn't there some way around double jeopardy if there's no overwhelming evidence? No. That was easy. We are still waiting for the Supreme Court to tell us whatever they're going to tell us. There apparently is no more decisions for me to speed read. It's very sad. Breaking and entering of the protesters and threats doesn't justify it. The breaking and entering wasn't onto their property, as far as I'm aware. It was into the complex as a whole, but presumably they don't have right. Presumably, I mean, I don't know how exactly it's set up, but I'm going to assume they don't have any particular ownership rights into the gated community as an entirety. So the thing that was broken into wasn't theirs. So their ability to exercise self-defense is not present because they don't have an ownership right over the thing that was broken into. It'd be like it would be like someone breaking into a store and me exercising rights. So my rights are diminished compared to like if it's my own property. So I don't think I think them having guns out and about is prudent, but I don't know that it gets you past brandishing. It doesn't get you past, particularly if they're saying threats, that can get you past the charges. The federal government's jurisdiction is somewhat more limited. So the federal government and state can both go after OJ or anyone else, but the federal government has to have a federal government hook. And I don't know if there was any hook in that case for the federal government to charge. There was no jurisdictional element that would apply. It happened wholly within someone's home. So there's no obvious federal basis to make a charge. The gate was badly mangled. Yeah, that's my understanding. The threat was not imminent and immediate. Yeah, as it applies to the homeowners, I think that, yeah. And also, there was one Kansas decision. Which I was like, really? But there was one Kansas decision from the Kansas Supreme Court that held even if there's imminent threat, you still don't have a right to brandish, which I thought was really weird because there was a case in Kansas where a guy had an imminent threat against him and of death or grievous bodily harm, and so he could have shot them, but he didn't. All he did was he pulled out his gun and pointed it at the guy, which seems better. And he was tried and convicted, and the Supreme Court upheld it because they were like, "Oh, you don't have a right to brandish the firearm. You could have shot them, but you don't have a right to brandish, even though there's an imminent threat." And I looked at that and I'm like, really? Really? So I have a right to shoot them, but I don't have a right to merely point my gun. So my choices are, once I pull my gun, is I have to pull the trigger or nothing. Like that's a great decision on practical grounds. Way to go, Supreme Court of Kansas. So I remember that one. That was genius. So if someone breaks into your neighbor's house, you just have to watch. Well, we know, but you're then basically trying to your claim there is citizen's arrest essentially. You're trying to effect a citizen's arrest at that point. So because they broken into your neighbor's house, so you're a third party. So no one personally is being hurt. So you don't have a third party self defense claim, right? If your neighbor is in the house, then you might have a third party self defense claim. But if your neighbor's not in the house, then you don't have a third party self defense claim. So now you're trying to do like a third party protection of property claim, which probably isn't going to fly. So then your next best idea is a citizen's arrest, and they are breaking into the house, which probably is a felony, and you can probably try to effectuate that arrest. But I would not particularly recommend it for all the reasons we've discussed in the Georgia case. I don't think citizens' arrests are generally advisable. First of all, they put you at massive risk physically, and they put you at substantial risk legally. So, yeah, you might be able to do something about it if your neighbor's house is being broken into, but it's not the same thing as your house being broken into. Your interests, when your house are being broken into, are your interests. So that makes sense. When your neighbor's house are being broken into, that's a third party interest. So your claims are more attenuated because of the nature of the situation. So if your neighbor's in the house, self-defense of others. If not, then defense of property of another. Good luck. Or citizen's arrest, not recommended. So, that's where you're at. Was the street private? Don't know enough about the relevant law to know for sure. Even if it's a gated community, the street may not technically be private. And even if it is private, again, it's not their property. It's the property of whomever. So it's still defense of third party property. So is the street private? Maybe. Even if it is, it's not their property, presumably. So same analysis. So yes, just watch because it's too risky to help his house. Yeah, that would probably be my best legal advice. Unless your neighbor's in the house. If your neighbor's in the house and starts screaming for help, then yeah, then I think you're probably in the clear. If not, then, you know, call the police, take photographs so they can be prosecuted after the fact. You can guard your property, but I think that you're going to have a bit of a tough time with your property of a neighbor. So that's what I would suggest. Where and when is citizens arrest appreciated? I mean, the best case for citizens arrest is if you're a security guard, that if you're a paid security guard by the place that's having you guide them, because you're a citizen, so you're engaging in a citizens arrest. So citizens arrest for paid security guards is appropriate. Also because they're trained and they know things a lot better and they know techniques, and so their legal protections are a lot better. But otherwise, I would not particularly recommend it. Can you not get past third-party protection of property for like statutes? I don't know what that means. Or would that only be two-party because it belongs to the public? I don't know what that means. Things are either your property or they're not. I mean, so, if your theory of the if the neighborhood, so maybe like if the neighborhood owns the property in common, and like each householder is deemed to be like a co-owner of the thing in common, then maybe. But like, yeah, then it gets a little bit more tenuous. So if you're asking me, if you're assuming that like each household is by the regulations of the neighborhood, if each household is by the regulations of the household, essentially what we would call a tenant in common of the entirety, then that would be a more interesting legal analysis, and I'd have to think about it a little bit. So if every household is definitionally a tenant in common of the entire thing, then the claim of defending the property would be a little bit more interesting. But I'm assuming that's not how it was set up. You would not only have to look at the property records, you'd have to look at like whatever um you'd have to look at like whatever association thing exists. And so you might have to look at this also in contract. So it may not necessarily be in the land records. It might be somewhere else. So you'd have to look to a whole bunch of things. So it's a more complicated legal analysis. Oh yeah, so we still have the faithless elector case still waiting. We have the Trump tax returns case. We have Where's Health of Oklahoma waiting. So that would be good. Association bylaws, yeah. Lighting, exposure, framing, color are just terrific. Thank you. I made some changes in the camera setting. I made some changes in OBS to make it better. Also, I changed the ISO because you can set it to auto and you can also select a maximum ISO. So I selected a maximum ISO. I think the one I picked is 1600, which is still pretty high because I think this camera is capable of like 128,000 or something ridiculous. But I picked like 1600, which is pretty high, to limit the ISO range so that it wouldn't like blow out too much, and also change the camera settings and also change the settings inside of Elgato screen capture. So change it there. I think I also changed the color profile from full to half. So let's see, let me just if I did that or not. No, it's still full color range. So I kept the full color range. So I was experimenting with that. Changed the color space. So I changed a whole bunch of things. I know the video is going to freeze for just a second. Give it a second. There we go. Because it takes, every time you change it, it takes a second for Elgato to catch up. Okay. So here are so there's an article that says here's the 9 remaining decisions. So we still don't have any decision from the U.S. Supreme Court, but we do have an article that was written about the decisions that are remaining. So we're going to read this decision and or read this article rather. We'll read this article and we'll try to talk about some of the cases that are still pending. So that'll be fun. All right, so this article was just written just now by Amy Howe. Hello, Amy. You looking good? What's up, girl? And then there were 9, these terms remaining decisions. With today's release of the opinions of, okay, so this was written actually a little bit old. So, okay, so here's the remaining cases. So we just did Espinoza. We just did Department of Booking. So here are the cases we still have left. Little Sisters of Poor St. Peter and Paul Home versus Pennsylvania, consolidated with Trump versus Pennsylvania, so a 3-fer. Whether the expansion of the conscience exemption from the Affordable Care mandate violates the ACA and laws governing federal administrative agencies. Don't know enough to really have an opinion. I guess I'd say probably not, just because it's a regulatory thing and we all know how far regulatory law goes, right? So my assumption would be no, it probably doesn't go too far because Chevron, Brand X, Our, it's probably all fine. So if I had to guess, I'd say no, the expansion does not violate whatever. That would be my guess. Bar versus American Association of Political Consultants. Whether an exception to government debt collection to federal law that bars robocalls is unconstitutional. Whether an exception to government whether an exception for government debt collection to federal laws that bars robocalls is constitutional. Okay. So there's generally a law that prohibits robocalls, but for debt collection, but it provides an exception for government debt collection. So is that unconstitutional? So we're thinking about an equal protection argument, maybe, that we're treating the government differently than like people at large. Yeah, I'm not seeing that really working. So I say no, it's probably not unconstitutional. That's probably okay. Our Lady of Guadalupe School versus Morrissey Boo consolidated with St. James School versus Bell. Whether courts can hear employment discrimination claims brought by teachers at Catholic elementary schools. Ooh, that's going to be interesting. It's going to probably get into part by what exactly do we mean by a Catholic elementary school? Because some schools have a secular side and some schools have a religious side. So it could get into that, but let's assume that this is just a straight up religious school. If the discrimination that we're doing is on the basis of religion and we're a straight up religious school, then we can probably do that. But the question is the scope of the ministerial exception. So that's relevant. So if it's a straight up 100% full fat religious school, then the relevant question is, does such a place qualify for the ministerial exception? So we know, for example, that churches can discriminate on the basis of religion in hiring of ministers, which is to say pastors. We know that because of course they can, because it wouldn't make any sense otherwise. So the question is how deep does the ministerial exception go? So we know a straight up church can discriminate on the basis of religion for a straight up preacher. That's fine. The question is, how far does that go? Does it apply for, and we know, for example, it doesn't apply, the ministerial exception does not apply to workers who are not ministers, who are just serving the church in general. So like lower level officials, we know it doesn't apply to them. So the question is, what about teachers at a religious school? Where are they on this continuum? That's a really good question. I don't know that the law really is clear one way or another. If it were up to me, I'd grant the ministerial exception for teachers at a full fat religious school, because the fundamental nature of it is religious teaching, the same as though it were a minister. So they may not be ministers, but what they're doing is religious teaching as though ministers. So they would get the religious exception as far as I'm concerned. So if they get the religious exception, therefore the courts cannot hear those claims. So I would predict the courts cannot hear those claims. That's super fun. McGirt versus Oklahoma. Where's Tulsa? No prediction. I think under the case law, the case law is Tulsa is not really in Oklahoma, but really no prediction, because God only knows, man. It's such an interesting issue that I feel like the court could do anything. So no bets on that one. Trump versus Marsa versus Trump versus Ducey, consolidated with Trump versus Deutsche Bank. Whether the congressional committees have the authority to issue subpoenas for the tax records. I'm going to say yes. Yes, they can, particularly from before he was president. So I could see a potential split on like after he's president versus before. Although personally, I wouldn't grant that split. Basically, Congress has the authority to issue subpoenas, and they have the authority to do so as long as they have a valid legislative purpose. And I think there have been like twice total that the courts have said, no, there's no valid legislative purpose. The valid legislative purpose goes pretty far. It may be once. So it's either once or twice, but it's not very often. And the last time it happened was like 50 or maybe it was 100 years ago. It's been a while. So I don't think we're going to do that now. So yeah, I think Congress has a valid legislative purpose. They want to look at possible ethic reform laws or whatever. I mean, it's not hard to think of one. So yes, Congress can get it. I think they can get it both before he was president and during his presidency. I don't think it's an undue burden on the, it's not papers of the president, right? They're personal records. So the fact he's president is kind of irrelevant. They're not presidential records. They're personal records. They're related to his personal taxes. And yes, Congress can get them. They have a valid legislative purpose. And yes, they can get him for him specifically because they're concerned about it and blah, blah, blah. So I would expect that Congress is going to get their tax records, yes. And if the court splits on that, they may split on the issue of before president versus during president, although I can't see an obvious reason why they would do that. So I think they get their records. Trump versus Vance, whether the Manhattan District Attorney can obtain the presidential records. Again, let me restate that because I misstated that in a critical way. So let me try again. Whether the Manhattan District Attorney can obtain the president's tax returns, not records, that's different, as part of a state grand jury investigation. Yes, for the same reason. They are private records of a private individual. The Manhattan District Attorney has cause because of the businesses that Trump was running in Manhattan, and they want to look at it. I could potentially see a split there because maybe there's like an equal protection problem, or maybe there's a what would be it, a malicious prosecution problem or something, or selective prosecution. because the Manhattan district attorney is looking at specifically this person versus other people where he could have it. So I could see like something like that, maybe changing that result when it comes to the Manhattan district attorney, who is a state official, incidentally. So it's the state of New York. Um, so I could see some sort of due process or equal protection or malicious prosecution or selective prosecution turning this analysis, but I don't think any of that applies personally, so I would suggest the same outcome. And finally, Chihuahua versus Washington and Colorado versus Baca, whether faithless electors can be punished. I think the answer to that question is yes, they can. So we'll see about all those predictions soon enough. So that was all good times. And we still have nothing further from the Supreme Court in terms of when more decisions will be released. So we don't know. And this stream has been going on for an hour now, so I'm just going to end the stream because we have no information. So we will be doing this at some point in the future. It also looks like yeah. I suppose also they could announce decisions later in the afternoon for no particular reason. That'd be fun. Um, but yeah, that is it for at least for now. So for the 95 of you who are currently watching the stream, thank you very much. I'm sorry we didn't get to see me do 9 speed reads, but we did learn some things. Booking.com is fine. We learned that. And what else did we learn today? I've already forgotten. Oh yeah, religious schools. We learned that we learned that the lemon test kind of remains alive on life support. General law of neutral applicability. So yes, you can give the money to the religious school because it's being done by the parent. You're doing it neutrally, and so the fact that it's public money going to the religious school is irrelevant because you are doing it on an even basis. So that makes sense. So I guess yeah, the religious schools can get their money, and all religious schools will be equal, and that's that. That totally makes sense. I'm no major problems. That's compatible with the lemon test. So that's what we learned, and we also had some discussion about the cases that are remaining, and we still don't know where Tulsa is. So where in the world is Tulsa? We don't know. So we will have to wait for that for another time. So until later, my friends, I hope all is well. And cheers and goodbye.